going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. Yeah, it's Wednesday. It's Wednesday. I had to think about that. Usually I think about what I'm going to say before I start. Anyways, it's Wednesday. Hope everyone's doing well. Good to see all you guys here. Also, thank you, Fred. Sorry, definitely not Fred. Fozzie. Thank you, Fozzie, for the $5 super chat. And maybe if I would have saw that earlier, I would have done that for you. But yeah, didn't see it till now. Yeah, but I'll go remove his message if you want. I think $5 is an appropriate price to remove a message. I got nothing. Anyway, thank you so much for that awesome way to start this video. Anyways, this is part 2 of the video I started Sunday night. I know it was supposed to be last night. Decided to spend some time with Heather last night, and then we had a little impromptu live, but this is part 2. This is what I would call the good part. Let's just say some people get kicked out of the courtroom for recording in court. Let's just drop that little nugget right now. Anyways, you guys are all awesome. What else I got? Before I hit that play button, you already know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Cases were taken for all sorts of activities that are outlined in the charges, and to that point, I'm going to go back.
I probably should say a few more things. For anyone who didn't see Sunday night's video, the defendant, she's standing at the podium with her attorney, is attempting to withdraw her plea. She took a plea deal. She embezzled, I think they say, almost $130,000 from her former employer. Her former employer, the victim, has since passed away since she took this plea deal. So she's trying to withdraw her plea because the state lost their witness. That's what's going on. Part 1 is in the description below if you guys want to check it out if you didn't see Sunday night's video. Sunday night was just kind of getting all the basics down, and the attorney never stopped talking. But this is when it's heated up. But I think I caught you up. The attorney he stated about 13 reasons why the plea she should be able to withdraw her plea. And now we got the judge's answer, I think. That's where we're at now.
Back to earlier in the transcript and talk about what she pled to. All right, so the examination gets signed, the waiver, and then the court, this is line 6. Page 18 says the following: Ms. Powers, reading the information, counts 1, 2, and 3 read as follows. That on or about the time period of April 2020 to March of 2022 in the city of Portland, count 1, that you were an agent, servant, or employee of J. Rocco and did take or secrete with the intent to convert to your own use without the consent of your principal money or other personal property of your principal having a value of more than $50,000 but less than $100,000 that came into your possession under the defendant's or control by virtue of your relationship with the principal. Mr. Merzlak interrupts. He said more than 50. Mr. English, more than 50 and less than 100. Mr. Merzlak, right. And then the court goes back to this process. So that charge, embezzlement 50 to 100,000, is a felony. Carries a maximum penalty of 15 years and or a $25,000 fine, 3 times the amount embezzled, whichever is greater. And a consecutive sentence can be imposed for any other conviction that the embezzlement victim, if the embezzlement victim was a non.
Welcome, Biggin, and all the Raiders. Thank you so much. I was checking in on you every couple minutes, Biggin. That hearing you have right now. Did you end up finishing it? I don't know. I had to leave before the end. I don't know. But that one's wild. That one's wild. A little long for my taste. This one is an hour and 45 minutes, and doing it in 2 videos kind of stresses me out. So you like the long ones, though. No, but that one's wild. Anyways, thank you so much, Biggin. You're awesome. I know I just kind of gave a recap, but with all the Raiders, I'll explain to you what's going on. This is part 2 of the video I played on Sunday night. The defendant was charged with embezzling $130,000 from her employer. Her employer since passed away, and they're trying to withdraw her plea. The defense is trying to withdraw the plea because the state no longer has a victim. That's what's going on right now.
Profit a person 60 years of age or older or a vulnerable adult. Count 2, line 13 now, page 7. Same date, location. You did utter and publish as true certain false, forged, altered, or counterfeit records, instruments, or other writings. Okay. And then finally, line 23, count 3, the exact same charge, uttering and publishing. And then goes on to state what that is in the maximum penalties. And then on page 8, line 8, court asks the defendant, do you understand the 3 charges and the possible penalties? And she answers, yes. How do you wish to plead? The defendant, no contest. All right, so back to this actual claim of innocence. Then the court, as I just read into the record, goes through the police report, 80% of it. He does find a factual basis for the 3 counts that she's entered a plea to, whether that includes checks, forgery, cash, whatever the situation may have been. The court finds a factual basis, and neither side offered anything additional. In essence, agreeing with the idea that what the court had in its hands was a sufficient factual basis for those 3 charges. So it makes it difficult now with the same information, in essence, the same police report, that there's a claim of factual innocence. The court, I can't see that or connect the dots based on this record. Count 2 is defects in the plea taking process. And before I get to count the second argument here, and count 1, actual innocence, I can't find that on the record. And then even if that had been shown, then the court has to weigh this issue. Can the prosecutor prove then there's substantial reliance or substantial prejudice if the court were to grant this? And of course we can. I think we can all recognize without a defendant present, there would be substantial prejudice to the people. But let's go back and then address item number 2.
Did you mean without a victim?
I'm sorry, without a victim. Yes.
All right.
All right.
Well, can I address briefly what the court
Sure,
just
Mr.
said?
English.
I take what the court is saying. I hope I am not interpreting the court as saying if I thought defendant was innocent, because the alleged victim died, the court would not allow her to withdraw her plea. Because obviously the court is entrusted with seeing that justice is done, and if the court found there was a
All right, come on, man. We all know what you're doing. We all know what you're doing. And I know I see all your guys' comments. She owes the estate. Yes. Yes. Her the person who owned the business, his kids are there, and they come up as victims here shortly. So you'll get to see them. And yes, I agree. I think that she would still owe the money too, but that's what they're trying to do right now. And it came up earlier. I think the prosecutor, maybe it comes up here shortly. I don't know. But the prosecutor says that once the quote unquote victim passed away, it's going to be really hard to push this forward. So this is a tactical move for withdrawing the plea. I'm not saying that there's no victim. And I agree with everyone saying that she still owes the estate. I agree with all that. But those were the prosecutor's words. Like I said, I don't know if that happened in part 1 or if that's coming up here shortly. I don't know. But I'm not just saying that because, I think I know what's going on. I'm not a lawyer. I don't know what's going on. But I agree with all of you that she would still owe the estate.
sufficient showing of innocence, would hope that the court wouldn't say, well, I think there's a showing of innocence, but he died, so too bad.
So I'm not certain that it exactly goes that way.
All right.
And I don't know that the court needs to get there anyway, because I've
Okay.
already found that on
Fair
this
enough.
record, I don't know that I can conclude that there's actual innocence based on what I've read in the transcript of what was offered in the acknowledgement of both parties here. But I would state this, and why I don't necessarily think that your argument is clear to me. Your argument is basically, if you find actual innocence, then the court doesn't even get to consider the second part, which is substantial prejudice to the people. In essence, your argument is once you find that, Judge, it's over. There's no more analysis needed. And I don't know that I find that accurate, particularly when I'm looking at case law here that was provided, which says that when a defendant moves for withdrawal of a guilty plea before sentencing, they must establish that withdrawal of the plea is in the interest of justice. Okay, you've got two prongs on your interest of justice, right? Actual innocence, defect in the plea taking process. Once you do that, this case law seems to suggest that if the prosecutor is opposed, the court must then, or the people must then demonstrate substantial prejudice would result. I don't know that we would have that second part at all in this case law if you were correct. If you determine actual innocence, then why does it matter if the prosecutor would be prejudiced or not? Why are we hearing from them? Actual innocence is end of story. None of the case law I've reviewed seems to suggest that. It all includes that second part that says, well, if you demonstrate it, then the prosecutor has a pretty heavy burden to overcome. They've got to then show that it would actually be substantial prejudice to them. So I don't know who's right.
Is my internet? I'm not getting a sign for my internet dropping, so I'll keep it paused for a second. Hopefully, it stops buffering for you. I don't want it to do that because this is when this really starts getting good, and I don't want to pause it a lot. Also, while I'm waiting for, maybe the internet to catch up, thank you for all the gifted memberships. You guys are going wild tonight. Fozzie with 5. Every time I see that, I think it's my name. Colin, definitely not pooping. I know you just wanted me to say that. Kathy, Barry, and Fozzie, 20 gifted memberships. Thank you so much, all of you. You guys are awesome. Welcome all the new members. As you saw Heather say, there is members only Monday. Some people call it Mom Day. Kind of weird. Started as a typo. And Fozzie, for anybody seen my cat, apparently he has my wallet again. Thank you so much, Fozzie, for the $20 super chat. All right, it's not buffering. Okay, let's go. Fozzie, you're awesome, man. I appreciate you. You know that. All right, if it's not buffering, let's keep going.
Mr. English, that's just my interpretation of what I'm reading here. I don't find actual innocence based on this record. And even if I did, I still think I need to go to that second part of what is being referenced in the case law about substantial prejudice. And again, I'm referencing it again because I think everybody recognizes with the victim, the now deceased, there clearly would be substantial prejudice to the people. So addressing the defect in the plea taking process. Now, this is a more interesting case, only because some of this is coming up in reoccurring comments and other issues with the court lately, as far as this indigent defense, how that's all supposed to take place, as far as appointment of counsel, things of that. They've just come up here. But I concur with the case law. They all share a case and the other cases that it points to, and that the court's got to find that there's been substantial compliance with the court rule. I think that's what the terminology is. Or if there is a deviation or a defect in the plea taking process, it's got to affect the substantial rights of the defendant. So Mr. English's argument basically is, if I could summarize it in a nutshell, the court didn't comply with the court rule, one, because it didn't inform the defendant of the right to the assistance of an attorney. Now, I guess I could concur that in the transcript, I don't recall a specific question from the court to the defendant that is along the lines, do you understand that you have a right to the assistance of an attorney? I don't think that exists in the transcript. And then there would be follow-up questions. And if you can't afford one, you'd be entitled to a court-appointed attorney. All the things we're all familiar with. But before we get there, I want to note the obvious. During this waiver and plea-taking process, the defendant was standing there with Mr. English. He's identified in the transcript. He speaks at that hearing. I think also it must be pointed out for a reviewing court here that Mr. English is a member of the public defender's office. So whether he was retained or not, he's a member of the public defender's office, and it doesn't change the court's thoughts here. The defendant is standing present with an attorney. Now, I think it would be nonsensical for the court then to inquire of the defendant a specific question that says, Do you understand, Madam Defendant, you have the right to the assistance of an attorney when an attorney is standing there assisting her and has already placed on the record before this plea taking process begins, the outline of the negotiations and the term, the outline of the plea that she's going to be entering into.
I can address that.
Well, I don't need you to address it because I've already heard the argument. So now the court's just making its ruling, and some other court's going to have to look at this in the future potentially and make a decision. It's just a court kind of thinking out loud while it's going along with its ruling here. So Mr. English is appearing on behalf of the defendant. It seems a little nutty that the argument is.
I agree with you, but what blows my mind is how easy it was for this woman to do it. She had a debit or credit card, I don't know, to this guy's bank account, and they're gonna break down what she's actually charged with here soon. Because yeah, you know what? I don't want to spoil it. I know there are more super chats. I'm gonna let it play for a few more minutes and I'll read them. But you guys are all awesome who are super chatting. I'm not ignoring you, but I'll give you shout outs in a second.
There's a defect to the extent that it's affecting the defendant's substantial rights because the court doesn't ask a very specific question whether she's informed of the right to the assistant attorney when she's standing there with somebody who the court recognizes as a member of the public defender's office. The other thing that I would note about that, which I think isn't relevant to this, but it's part of my curiosity, I suppose, but I think it is interesting. I've recently had emails with the public defender's office about MCL 780.991, which is the establishment of the IDC minimum standards, rules, procedures, most importantly, application for an appointment of indigent criminal defense services requirements. Now, there's no doubt that that statute empowers the court, district, circuit, probate, whoever, to appoint the public defender's office if they find that they're indigent. However, the act very clearly, now I'm going to read from 780.991 subsection 3A, says that the appointment of counsel to indigent defendants is the responsibility of the local IDC office. It says under 3A, a preliminary inquiry regarding any determination of the indigency of any defendant, including a determination regarding whether a defendant is partially indigent for purposes of this act, must be made as determined by the indigent criminal defense system, not later than at the defendant's first appearance in court. The determination may be reviewed by the indigent criminal defense system at any other stage of the proceeding. So how is that applicable here? Well, it's the court's belief this act is clear. The IDC, in essence, Mr. English's office, has to make these determinations. He's standing there appearing at this waiver and plea with the defendant. I think the district court, the circuit court, when IDC members appear with the defendant, certainly can take note that there's been a determination that this defendant is indigent and they actually have counsel. But I went back further in the file. Nobody's referenced this, but the court can take judicial notice. I don't know what happened between October 20th of 2022 and then October 20th of 2023. It's ironic that the dates are the same, but 1 year earlier, the defendant signed a felony advice of rights form. This felony advice of rights form says the following: you have been brought before the court on a felony charge. You have the following basic rights. You have the right to remain silent. Number two, you have the right to the assistance of an attorney and have an attorney present during any questioning consented to. If you can't afford to hire an attorney, you have the right to an attorney appointed at public expense. However, you may have to reimburse the court for the expense of the court-appointed attorney. Subsection B of 2 says you have the right to be represented by an attorney at all subsequent court proceedings. And then 3 is the right to consideration of a pretrial release. And then that's signed by Teresa Powers with the same address, 12768 Georgia Ave in Grand Ledge, that she used when she signed on 10/20/23. I don't need any more argument.
I'd like to comment.
But
if the
we've
court
already
doesn't
passed
wanna
that
do it-
stage. Nobody thought that this was important. The court does. So I don't need more argument. I always try to give both sides, as much as it's difficult to sit through sometimes, the opportunity to say everything they want. I try to just allow both sides to talk, even though sometimes the court's already heard enough.
Well, I only
And I
talked
have
about
done
the
that.
motion.
I have done that.
There were a few comments I had, but
I
could the
haven't done
record
that.
reflect that the email back and forth?
All right, that was a great place to pause. Look at him. Look at the judge. He's like, "Come on! Like I just told you, I've given you enough argument time. Stop. Just stop." Yeah, he makes a comment about it later. It's kind of funny. Anyways, let's get to these super chats because I don't want to get too far behind on them. Let's see. I think this is where we were at. So Fozzie's cat, nope, haven't seen your cat, but I did find this day the catnip. Thank you, Thorina. The cat theme's been a thing for the last couple of weeks. Legal fiction. Fozzie's cat handed me some guy's wallet. Well, thank you to the random guy, and thank you, Legal Fiction. You're awesome, man. Deborah Jean found this in Fozzie's cat litter box. It's yours if you really want it. I mean, because it's digital, I don't have to touch that. But thank you for grabbing it out of the litter box for me. I appreciate that, Regine. All right, Sparkle Poo, Squadron in the litter box left this litter box theme now. Thank you, Sparkle. Or what do we? Spookle parts. And Jedi, your effing cat just busted in and took this from me. You know what? That cat, man, getting around. Thank you, Jedi. Sparkle Poots again. There are no bad critters, just bad owners. Yeah, I agree. But this has been a very lucrative cat, so I think Fred raised him right. All right, and the beautiful Heather. Fozzie, your cat ate my tuna, but left me this. And yeah, I saw the comment. At least the cat paid for his meal. This is true. Thank you, Heather.
Did not occur between the court and me, correct?
What email are you talking about?
The court referenced email correspondence
With your office, yeah, with Mr. Downs, yeah.
It didn't involve me.
Sure, yeah.
Sure.
So, and I said, that's not relevant to this. It's something the court finds interesting, and it's something that I think might need to be ironed out in future as to your office is the entity who is empowered to make these decisions. And so when people are appearing with somebody from your office in front of them, the court has to assume, because you're the entity empowered with that decision-making process, that you are there on their behalf. You've made this determination. And even if you haven't, I guess you're still standing there with them, with an attorney. But getting to the point of this, the court can take judicial notice this morning, though neither side argued this, because it's in the court file directly in front of me, that a year earlier, on the same day of October 20th of 2022, the defendant was advised of her right to have an attorney. And then interestingly enough, the next 4 days later, on October 24th of 2022, the IDC, Mr. Downs, filed an appearance and demands. So the defendant was represented by an attorney, as far as I can tell, since October 20th, certainly since the appearance and demands was filed on October 24th of 2022. So let's fast forward a year later. I don't know what happened, if she absconded or the case went slow. I don't know. But it's unquestioned from this file that Ms. Powers had counsel, and she was advised of her right to have counsel. Now, going back to the court rule again, I'm going to acknowledge that MCR 6.6610 subsection F, flying down to subsection F2, the court shall inform the defendant of the right to the assistance of an attorney. Again, I don't recall reading that in the transcript. We've had discussion about that.
It's not in the transcript.
However, excuse me.
It's not in the transcript.
Right.
That's why the court doesn't recall it.
However, Mr. English does stand there with her throughout the proceedings. In fact, in the transcript for the defendant, first page, Mr. John English, Iron County Public Defender's Office. And when the case is called, I'm going to refer to page 3. Let's call 22-903-FY, the state of Michigan versus Tucson Powers. We're here for exam. Are both sides ready to proceed? Mr. English answered in the affirmative. Defense is ready. Mr. Merzlak says, yes, Your Honor.
You are exactly right, Jedi. That's exactly what the judge was saying right there.
And then we get on to this. So, Mr. English, for a reviewing court, I acknowledge that this transcript is devoid of a specific question informing the defendant of the right to the assistance of an attorney. However, counsel's present. They're standing there with her.
There's another question.
Yeah, that's one of the 10 reasons why they were trying to withdraw her plea. Ineffective counsel was one of the 10 things that he said. So yeah, they are claiming that.
And
That it's devoid of.
so, Mr. English, please, I recognize you want to say more things, but I just want to deliver
Wanna
a
make sure
opinion.
Court
So-
has its facts.
So, and I'm trying my best to make as clear a record I can to tell the appellate court why the court's ruling in the manner that it is,
Thank
and
you.
how I think it meets the court rule. So again, no specific question, but counsel is present and is acknowledged in the affirmative that he's there on behalf of this defendant. And then going further back in the file, there's an appearance and demands. An attorney, the public defender's office, has filed their appearance on behalf of this defendant. And then on October 20th of 2022, there's no question the defendant was given the instruction that she has the right to the assistance of an attorney. And in fact, that did occur from that day on in this file. So I don't find the absence of that specific question something that is fatal to the plea taking process, or a defect if we using case law that affects her substantial rights. To the contrary, she was well represented that day. Mr. English made clarifications during this whole process of what was going on and what he, her attorney, had worked out on her behalf. Now, the other part of this defect in the plea taking process, this argument, is the idea that there's no reference to the document in question. So this court and both sides acknowledge that there was an advice of rights. It certainly was referenced during the plea taking process.
No,
Mr. English,
that is not correct.
let me finish, sir. You've already made that argument. Mr. English has argued that because it's not, again, that specific question isn't asked about this form, certainly was provided later. It's certainly part of this plea taking process, that somehow that means that it's affected her substantial rights. I'm going to read from the court rule again, 6.610F, now it's subsection 4. A defendant or defendants may be informed of the trial rights listed in subrule 3B as follows. On the record, in writing, made part of the file. There's no doubt this advice of rights signed by the defendant on October 20th is in writing. It's part of the file. And C, in writing referred to on the record, in which case Mr. English might be correct. Maybe it wasn't specifically referred to on the record. And then the court rule goes on to say, except as provided in subrule F7, if the court uses a writing pursuant to F4 or C, the court shall address the defendant and obtain from the defendant orally on the record a statement that the rights were read and understood and a waiver of those rights. In fact, the waiver may be obtained without repeating the individual rights. So that last paragraph, and I've already referenced it, let's refer back to the transcript.
That's not in the transcript.
Mr. English, just let me finish, please.
Yeah, an attorney being held in contempt would be, you would really have to be getting under the judge's skin. And the judge will warn an attorney multiple times, just like he does with anybody else who's not an attorney. But yeah, the judge is definitely getting a little frustrated. He doesn't show his frustration. He doesn't wear it on his sleeve like some of the judges do. But yeah, he does make a comment later in the video that the attorney was just going on and talking way too much. So that's about as close as we get to any kind of warning. But it's after the case is over.
So let's go back to the transcript, which indicates that the court can then have a record that's part of the file, refer to it on the record, and then the defendant orally on the record can give a statement that the rights were read and understood. All right. So on the record, on page 9, in relation to these rights that we're all referencing. Now, I recognize Mr. English says that let's not care what rights we're talking about, but I think that is just a nonsensical, ridiculous argument. That's his task as her attorney, to make sure that she has covered the rights we're all talking about, the rights that are then provided to the court. Part of the file on October 20th, the defendant signed and understood. So here's the question on page 9, line 1, the court addressing the defendant. Do you understand that, therefore, it would also mean that you're giving up the right to have a trial? Have you and Mr. English gone through these rights? And the answer from the defendant on line 4 is yes. Next line, line 5, the court, would you like me to go through them? The answer, line 6, no, that's okay. Line 7, do you feel like you fully understand these rights? Line 9, the defendant says, yes. Then by pleading no contest, you give up these rights. Line 12, the defendant answers, yes. Going back to subsection 4 of 6.610F, subsection 4, court can, as outlined here, the court uses a writing. The court shall address the defendant and obtain from the defendant orally on the record a statement that the rights were read and understood and a waiver of those rights. And that's exactly what happened. That's exactly what the court asked about. I know you disagree, Mr. English, but that's not the court's interpretation of this transcript. That's exactly what happened here in compliance with subsection 4. And then that writing it's being referred to, titled advice rights, was actually provided to the court. It's part of the court.
That's because he's reading the transcript of when she pled. Like, oh, you didn't understand your rights? Let's go through the transcript, and I'll tell you exactly what you said when I asked you about your rights. All right, while I'm paused, peeps, thank you so much. Fozzie Cat was here, seeing my pink hair, and the chat disappeared for me. Oh, where'd it go? Saw my pink hair, butterflies, and scampered out the window. Drop this, and pink hair rules. Your hair is awesome. Your hair is awesome. Also, check out Peeps' soaps. Check them out. I'm sure now that I just said Peeps' soap, she's going to drop a link. Check them out. They're awesome. They're amazing. Heather can vouch. Fuzzy, people, you didn't turn him into a Bengals fan, did you? He was already a Bengals fan. He's a cat. Come on. No one's rooting for the Panthers anymore. Or the Jaguars. You know, there are some Jaguars fans. What other cat teams are there? You know who we're not, you know who the cat's not a fan of is the Cowboys or the Steelers. That is all we know. And that's fact. It's science. You can't argue with science. The cat is not a fan of either of those teams. All right, let's go.
File.
Judge, it is not part of the court file.
It's right here. It's in the court
It was
file.
not. It was provided to the court after the hearing concluded.
Yeah.
There's no question that the court did not question her about that.
I know you made your argument, but I interpret when he says, meaning the court, have you gone through these rights? And she answers yes. Would you like me to go through them some more? And she says, no, that's okay. Okay, and then a document is provided titled advice or rights. It's a nonsensical, at least in the court's mind, Mr. English, and
I have no issue with the Cowboys. I really don't. The only team that I mildly dislike are the Steelers. That's because I'm a Bengals fan. I was going at Fred, so that was a Fozzie thing. I really don't care either way for the Cowboys. I don't like them. I don't dislike them. So, all right. He steals my wallet. Definitely a Steelers fan. Yeah, I do see what you did there. Good job with the dad joke. Thank you, Fozzie. And again, the beautiful Heather question: will I fall asleep before the video ends? Most definitely, because you wake up so early and you're in a different time zone. All right, let's keep going.
patient as I can with this. You've certainly preserved the issue that we're talking about these advice rights outlined in the court rule.
All right, thank you.
I do not find then with the second prong of this argument that there's a defect in the plea taking process. And again, going to the Alsure case, if I'm pronouncing it correctly, is there a deviation in the plea taking process that would have substantially affect the rights of the defendant? No. Do I wish, Judge Vogt, in a perfect world, and keeping in mind the district court is a mash, I like sort of a mash unit where they're handling dozens and dozens of cases every day. I wish he had asked some very specific questions like, do you understand you have a right to an attorney? Ignoring the fact that there's an appearance in the file by the indigent defense office that she's standing there with an attorney who's already placed on the record the outlines of the agreement, everything that's going on. So I wish he'd asked that specific question. Yeah, but does it affect her substantial rights? No.
Judge,
But when we're going through, sorry, this is what he said.
he didn't ask whether or not it was the defendant's own choice to plead guilty, and the court hasn't addressed that.
Don't like any more arguments, please. I've already given you the opportunity to do that.
Thank you.
All right. So the referencing that I have just read on the record here is one and the same, those rights. Now, what was the last issue you just brought up, Mr. English, that apparently the court has not got to?
I'm going to say subparagraph 6C says, in part, the court must ask the defendant, subsection C, whether it is the defendant's own choice to plead guilty.
Okay.
That was not asked. That is not in the transcript.
All right.
That is mandatory.
Mr. Merzlak, only because I don't recall this earlier, so I don't recall if you had a response to that. What's your response to the court must ask whether it is the defendant's own choice?
Your Honor, I would say that the court did ask questions along those lines and resolution that promises any other things not placed on the record. And also that it's not so it's not a divorce.
All right. So Mr. English, again, addressing that very specific issue, you're right. Because I don't, maybe this came up the last time. I don't know that that specific question was asked at all. However, the court did in finishing the plea taking process. I'm going to read from line 311. Are there any other promises, threats, or inducements? You actually answered for her. Mr. English, no, Your Honor. Mr. Merzlak, no, Your Honor. The court then says to Ms. Powers directly, is there anything else getting you to plead no contest other than what we put on the record here today? No, sir. And the court says, I'll accept your plea. I find it to be knowing, accurate, and voluntarily. Again, going back to the language of statute, of case law here, of the controlling authorities, is there a defect affecting the substantial rights of the defendant? I don't think so. Mr. English has preserved for the record these issues. One of them being, I guess, another specific question that he thinks makes it a fatal defect, if you will, whether it's the defendant's choice to enter this plea. I think reviewing this transcript as a whole, there's no doubt that this was the defendant's choice to enter this plea, that it was the choice of her counsel that she entered this plea, that she's been given all the advice, all of her rights protected. Mr. English certainly does that as well as anybody. And certainly if you read this transcript as a whole, did the same there. I just don't find that there's a defect in this plea taking process. Certainly not one that would take it outside of the realm of substantial compliance, or in the alternative, one that would result in a deviation that is affecting the substantial rights of the defendant. So respectfully, Mr. English, I'm going to deny, for the reasons stated on the record, your motion to withdraw and ask you to prepare an order that indicates the same.
It's prepared.
Okay, so then I'd be happy to sign that, and then I think we can proceed to circuit court sentencing.
Yes.
All right, then I'm going to go to you, Mr.
All right, we're proceeding to sentencing now. All those excuses. Now we're 39 minutes into this video. The video from Sunday was about an hour and a half. I know there's a lot of me talking, but I mean we're at least at about an hour and 20, hour and 30 minutes of the defense attorney just rambling. And judge shut him down. No, we're not doing that. And we're about to hear why. But yeah, we're gonna hear from a victim here. And people get kicked out of court. I think someone did in the first video. 2 people get kicked out. So maybe both those happened in the first video, because we're getting late into this video now. So I don't know if this happens. Also, Sly. Thank you so much, Sly. Let me make sure to read it. For the PayPal, I threw my shoe at Fozzie's cat. I missed, but he dropped this from Sly. Thank you, Sly. Very much appreciated. PayPal, everything in Linktree helps me huge because I can, it's YouTube doesn't take its cut and it's instant, right? With YouTube, we gotta wait till the next month for them to send me a check. Sometimes, sometimes they take it back. The monetization. Anyways, you guys are awesome. Thank you so much, Sly. Let's keep going.
Mr. English, I have in front of me a pre-sentence report. Have you had an adequate opportunity to review that with your client? And if so, do you have any additions, corrections, or deletions?
Thank you. Can I approach with the order?
Sure.
Should have been in the court's file as well, because I usually file.
All right, so for the record, the court is reviewing the order. The reason statement on the record, okay. Signing that, I'm going to hand that back to Mr. English to have it filed.
Thank you.
And then back to the questions. Did you have a chance to review this with your client?
Yes.
Additions, corrections, or deletions?
No additions, deletions, or corrections.
So you believe we have accurate information on which to base that?
Yes.
Mr. Mirzak, anything on behalf of the victim or the people?
Nothing for Your Honor, as far as additions or corrections or anything like that, but we do have the stepson of the victim, Colin would like to make a statement.
So, Mr. English, if you and your client could have a seat at the table there, and then you can have that individual come up to the podium, and then when they arrive, they would raise their right hand. Actually, you don't need to raise it, just state their name, spell their name on the record. What's your name?
Harlan Medalin.
You don't need to raise your hand. And how do you spell your last name?
Medalen.
Medalen. All right, what did you want to say this morning?
Well, first, I would like to say my humblest apologies to the court, and I greatly appreciate the time and diligence Your Honor has given to this matter involving my deceased father. Jerry was married to my mother for 32 years. He was a devoted husband. Sadly, my mother preceded him in death 7 years ago. He had no biological kids of his own, but he raised my brother and I as his own. While legally my stepfather, for all intents and purposes, he was my dad. He had a distinguished career dedicated to public service. He was an EMT when he was only in high school, then served 2 terms in Vietnam, where he retired an officer in the Navy. He was honorably discharged. He was a police officer, became a college professor at Lansing Community College for over 20 years, and finally retired from Sparrow as a cardiopulmonary functionologist. He ran their cardiodiagnostics lab. He was a good man. He always did for others before himself. He trusted Teresa. He was good to her. Teresa had no right to violate his trust. What Ms. Powers did to him was reprehensible. It broke his heart and shattered his faith in the goodness of people. The stress caused by her action.
All right, this is the only time I'm going to pause it during the victim impact speech because Erica asked for me to catch her up. This is the son of a recently deceased man. The defendant, who I can't see where she is, the screen's too tiny. She was trying to withdraw her plea of guilty to embezzling $130,000 from the victim who has since passed away. So there was about an hour and a half worth of defense attorney word salad, and the judge says, no, you're not doing it. So they moved on to sentencing. So that's what's going on now. So this is a victim impact statement of that.
Has led to a premature decline in my father's condition, both physically and mentally. He had given up on living. Unfortunately, he did pass away unexpectedly 2 weeks ago and couldn't be here to see justice be done and give him peace. Thank you, Your Honor.
Okay, anything else then from the people?
Yes, Your Honor. So you have a guideline range of 29 to 57. I note that there is no sentence agreement. For this sentence, the defendant within these guidelines, I would suggest a sentence of the range from the middle to the top of these guidelines. We will stay within these guidelines. I also note that the other publishing charges, counts 2 and 3, well, the count 1 has the possibility of a consecutive sentence. That information was provided to the defendant, knows that, was right for the scoring for the other with this PRB level C and OB level 4, on the either that'd be 5 to 10 to 3. So if the court were to entertain that consecutive sentence, which the defendant has earned with her actions, the sentence, the guidelines of the other publishing 5, 29, 7 for the embezzlement. But I think the defendant deserves a maximum type sentence because of her decision to steal from Jerry. Not just once to get some food, not just a few times to get some clothes or food or beauty products, but multiple times, hundreds of times, over months and months, over years, making sometimes stealing from him multiple times a day, doing multiple ATM transactions where she steals cash from Jerry's multiple times in one day. She has to make that decision. Every time she does that, she's making the decision, I am going to commit a crime, I am going to steal Jerry's money. And she does that hundreds of times, multiple times a day, for months and months, for years and years. And she is Jerry's.
Thank you so much, Ann. That was very generous. $50 super sticker from Ann. You're amazing. Very generous. I very much appreciate it. Thank you. I wasn't going to pause it because I wanted you guys to all hear what the prosecutor was saying, but sorry, $50 super sticker. I will pause every time for. And you're awesome. I hope you're having a great evening. And thank you.
Caretaker. She has Jerry's trust, and she violates that trust, and she makes the decision to steal from Jerry hundreds of times. This case was delayed in district court. I understood the magnitude of this case. I had not seen an embezzlement case with this amount of money that was stolen. I knew the case would be difficult because the defendant did admit to stealing from Jerry, but she did start to say that, well, she started to question individual transaction. So we needed
For 2 seconds. Thanks, Fozzie.
we needed Jerry's bank account information before Teresa came into his life, while Teresa came into his life, to show the how the spending habits of those accounts changed when Teresa came into Jerry's life and started stealing them. That's a lot of bank records. Jerry had multiple bank accounts. These records need to be certified. I did not want to go to an examination without knowing full well. Basically, we had proof beyond reasonable doubt that because of the case of the magnitude. And the offers I gave to Mr. Downs were for her to plead the felony. The response, what the defendant wanted to plead to was a misdemeanor. And I recall they wanted restitution of $1,000 with a misdemeanor. And I said, absolutely no, that would not achieve justice in this matter. It will not deter other people from stealing from people like Jerry. It will not deter people from stealing from someone who trusts them and who they're supposed to be taking care of. it needs to deter them and it needs to deter this defendant, and it's $1,000 is not gonna do it. So there were some adjournments because of that, both parties preparing for a hearing. And then Mr. Downs substituted Mr. English in to represent the defendant, which is his power as a public defender. So then we essentially start over. Here's the evidence against your client. This is how serious it is. What does the client want to do? We get to the examination day. I think we're going to run the exam, and then we enter into these negotiations, and we end up with this plea, which I think gets us to justice, but I mean, it depends on your sentence. But again, I'm asking for, if you stay within these guidelines, middle to top of the guidelines, there is no sentence. And I think there are reasons why you might see the guidelines. And also, the defendant knows about the second sentence. I ask you that you keep that in mind. Again, other than publishing is 5 to 23, and we have count 1, 29 to 7. Thank you.
All right, before we begin, officer, do we have a sign out on the other side of that door about cell phones and interruptions in the courtroom?
Yes.
All right, why don't you take that cell phone too for the time being? All right, Mr. English, what do you want to say on behalf of the?
I would note for the record, my recollection is that at the initial sentence hearing, the court spent a certain amount of time advising counsel and the defendant how seriously the court took a charge of embezzlement. And the court indicated what Mr. Merzlack just repeated back to Your Honor. The court indicated that every day somebody gets up, they're thinking they're going to commit another crime, day in, day out.
Now you're using my lines.
I'm using
not gonna
your
be able to use
lines
them now.
because that's what the court said. The court also pointed counsel, that would be me, to a case. The case was unnamed, but because Your Honor couldn't remember the defendant, but Your Honor said within the last year or so,
Oh, my
I had an embezzlement, I clocked her good. And in so many words, Your Honor made clear, your client's gonna get clocked too.
Well, that's because that defendant had a trial. So all their agreements were off the record, right? She was not protected by any sort of plea agreement as your client is. She went to jury trial and lost and convicted her of a little different situation. But there's no doubt that these, as Mr. Merzlack has represented, and which maybe the court pointed out in this prior hearing that we were just here briefly, that there's substantial penalties associated with these crimes, including one of the few times the court can impose consecutive sentences.
I'd ask that the court adopt the recommendations, and the recommendations are stated on the Department of Corrections recommendation as to counts 1, 2, and 3, including a recommendation that the sentences are to be served concurrently. And that's what I would request. Thank you.
Okay, Ms. Powers, is there anything that you want to say before the court closes sentence?
No, sir.
All right. So you do stand before the court this afternoon with a guideline range of 29 to 57 months. And the positive with this, Ms. Powers, is you stand before the court as somebody who's 52 and no prior criminal history. When I reviewed the PSI some time ago, and then again, I guess, this week in anticipation of sentencing, I was struck, I guess I don't recall any sort of connection as to how the victim and you ended up together, if that was some organization that was hired or a neighbor or a family friend, however that came to be, but it was ended up in hindsight being a pretty awful outcome for the victim here. Mr. English is correct, and it's not the court's own thoughts. I don't take credit for this. I learned from Judge Hoare this idea that when we have crimes of this nature, and then it sort of adopted the same mindset as a prosecutor and then on the bench for several years now, that unlike crimes that can be maybe even a series of bad decisions on one night, right? So the bad decision is I choose to go out to the bar with my friends, and then the second bad decision is I choose to drink, and third bad decision I choose to then get in a car and drive, that kind of thing, and someone's hurt or seriously injured. Those types of crimes, many crimes that we deal with, are confined to a decision or even a series.
Yeah, that's actually a question I asked Judge Slavin on Monday night when he was on. It was in the post I made asking everyone had questions. Somebody asked a question about it, so I did, and he had a really good speech on it. So if you haven't seen it, Monday night he was on the stream. It was towards the end when I started asking him questions from the audience. So yeah, go check that out.
Decisions in a very tight window. It's not the case when we have embezzlement crimes of this nature, embezzlement crimes from the elderly amongst us, right? The vulnerable amongst us. Those individuals that are engaging in those crimes have to make a conscious decision every time that they are taking money they're not authorized to have, using a credit card, a check, whatever the case may be. And then in the case of this is no different, yours, actually not only make that decision, but then have so much time to reflect upon it. For instance, taking the debit card and driving all the way to town, a few blocks, whatever it may be, to then get into the ATM and input the information, or for instance, write the check that you're not authorized to write for whatever reason. To go through that action and to go someplace to actually cash that check. It's ongoing, and as has been mentioned here, this one is the same as many that we see, where then it occurs over a series of days and weeks and months and sometimes years, right? Where the defendant is making these criminal decisions, conscious decisions, over and over and over to break the law, to victimize whoever is the other party involved. And so the point that Judge Hort was making, and one that the court finds compelling, is that when we're dealing with these kinds of cases, you have somebody that has made the same decision over and over, over and over, over and over. In essence, I'm going to continue to commit this crime. I'm going to continue to victimize somebody. And there's, I think, a lot that can be said, that can be gleaned from the idea that you have somebody that makes these decisions time and time again. It's not a one-time bad decision. It's not a one-time bad night kind of thing. It's a continual issue. The other thing that I would note as it relates to these types of cases, and the victim here is no different, there's been an emphasis on this. And I mentioned that because there'll be some incarceration here, Ms. Powers, and when the court considers incarceration, there has to be some reasons for that. In the legal sense, the two.
All right. I know there's not a lot of bangers on this video. There's not a lot of high drama, which is a very interesting case, but this is as close as it gets. So I'm going to tell you right now, it's about to go down.
Big ones for incarceration are, one, punishment. Should they, and do they deserve to be punished for their actions? Well, of course. Number two, the big one is deterrent, right? We want other people to see that crimes of this nature, why somebody's being sent to incarceration, are something they shouldn't consider, especially when we have to make the decision over and over and over. And it's not just this court's thoughts with that, right? I can recall just a couple years ago, the Attorney General, Dana Nessel, had a whole task force on vulnerable and adult abuse, these types of crimes, embezzlement, and even got Supreme Court justices to go out and do their little Q&A with different groups. So you actually, not only, I'll leave this to Mr. English, if maybe you know their published, I've always wondered if the Supreme Court had to rule on an issue of this nature in one of these cases. How are they neutral and detached when they were appearing with the Attorney General's office on these very issues? Now, That's a different subject for a different day, but the point of sentencing and where I'm going with deterrent, it's a big deal. It's important because if we're talking about deterrent, it shouldn't be lost on anybody that reads the news that the bulk of our population, or the biggest majority, I should say, is made up of baby boomers, guys, Mr. English's age, maybe even Mr. Lewis, I don't know, Mr. Lewis, right? But that's a long way of saying that these folks, as they age, are the kinds of folks that are going to need caretakers. They're going to need help. Will be the largest transfer of wealth in our nation's history as these baby boomers die off, right? And nobody wants to see that transfer of wealth occur because it was stolen from those individuals. So I suspect, and I assume that's why the Attorney General's office has emphasized this, and even members of the Supreme Court with her, to emphasize that they're on the lookout for these types of crimes. We do have this aging majority of our population out there that's going to need help, going to be subject to folks like you that are going to victimize them. Again, I'll trace back to not just a one-time decision, but a decision that's made over and over and over. So there'll be incarceration. Courts articulating why I think that's important, why I hope it serves as a deterrent, why I do believe that it involves punishment. This is not an insubstantial amount. PSI references over $130,000, multiple transactions, multiple times a day in some instances. And again, I'm going to balance this with the idea that you're 52, you have no criminal history. Now the court, I like to use the guidelines and I like to start at the middle and then I tailor a sentence that's individual to each defendant, facts and circumstances about you, information about you, and then facts and circumstances of a crime. Mr. Merzlach's correct. The court could impose a consecutive sentence here. I find it a little bit frustrating that we have guidelines of 29 to 57 on a financial crime. So I'm not minimizing financial crimes, particularly with the mindset that goes into it, but with real crime, I should say that, with crime that results in real injury, physical harm, and even death, sometimes we don't get guidelines like this. So that's kind of odd to me as a function of our system. But the guidelines are what they are, and the court is bound by those guidelines, Ms. Powers, and I'm going to give you a sentence that's right in the middle of the guidelines. And I think that is appropriate based on the facts and circumstances of this case. I think it's appropriate, hopefully as punishment and a deterrent. And then I hope that this case, amongst others, again, there's a Montcalm County case I recently did, resonates with the public.
All right. Let's see where we at. Hour and 42 minutes. This video is, sorry, I should have done this before I paused it. We still have 10 minutes left. All right, so we're good. I was going to say I'm going to let it play out because it's such a long video, that little timer button is getting closer and closer to the end. We still have 10 minutes. While I'm paused, Sparkle Foods, thank you so much for the 5 gifted memberships, and welcome to all the new 5 members. You guys are all awesome. All right, let's go.
There are other folks that are going to either have parents or loved ones that are in these situations, or that would be doing the same kind of work, but they think twice before taking on these kinds of decisions. All right, so the first thing I'm going to do is order restitution, the amount of $100,000 that's payable to Jerry Rocco. And then, yes.
Sorry, I have to interrupt. Because the victim is deceased, the statute does talk. NCO 780.766, paragraph 7, says that if the deceased or dies, the court shall order that the restitution be made to those entitled to inherit from the victim's estate.
What is that
So you just
statute?
make that state.
All right, so
What is that statute, please?
The statute is the Crime Victims' Rights Act, 780.766, paragraph 7.
So I'm going to order the restitution to Jerry Rocco or those entitled to his estate. All right. And then we'll cite in there that MCL, Ms. Bond, you can get that from the prosecutor later. And then, like always, Mr. English, certainly you can then file a motion as it relates to restitution if you need, or if you think that it is appropriate. All right,
If I may, on that question, for the record, I don't think we can file the motion for restitution.
well, if that's part of the plea taking process, then you have an agreement in place, all right? So I read that somewhere too, but that's off my standard script in something, okay? So I'll leave that to you parties, all right? As it relates to the next thing, Ms. Powers, I'm required by statute. I will impose a $130 crime victims assessment. Required by statute, will impose a a $204 in state costs, and that's broken down $68 on the 3 counts. There'll be $60 for DNA testing fee, and then court-appointed attorney fees of $400 and $350 in court costs. And none of that, to the extent is required, should be collected before the restitution. And then Ms. Powers, on count 1, court will sentence you to 43 months with the Michigan Department of Corrections to statutory max of 15 years. You will receive credit for 9 days that you have previously served. On count 2, the court's going to sentence you to 43 months to statutory max of 14 years with the Michigan Department of Corrections, again with credit for 9 days you previously served. And then on count 3, 43 months to statutory max of 14 years, credit for 9 days you previously served. Counts 1, 2, and 3 will run concurrent, one with the other.
Thank you.
Ms. Powers, you do have a right to seek appellate review of the sentence and then all the other appellate issues that Mr. English has preserved for you. If you'd like to do that.
Yeah, she got about 3.5 years. That's what she was sentenced. Stole $130,000, got 3.5 years in jail. They're all running concurrent, so she's going to serve 3.5 years. Or I don't know what jail she's going to. I don't know how the good time works, but yeah. She's gonna serve. She's serving some time, and we're about to get the satisfaction of hearing those silver bracelets here in a second.
You have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 days from today's date to make that request.
Your Honor, she is so requesting, and we have a writing that evidences that.
So let the record reflect the appellate paperwork has been signed and acknowledged with today's date. So we'll place that in the file. Anything else, Mr. English or Mr. Mirza?
No, Your Honor.
That'll conclude the matter. Ma'am, you could just have a seat right over there. And well, you have a key? Instead of her having a seat, you can just go to that.
Thank you.
Okay, what do we have next?
Oh, Terry Vandenberg.
Oh no! The judge told her to sit down. It looks like I clipped ahead because I'm going to show you the quick hearings of the 2 guys that were held in contempt or got kicked out of the jail. So yeah, or the jail, kicked out of the courtroom for. Yeah, one of them was recording. One of them's watch was going nuts. Fred, thank you, Fred. I appreciate it. Thanks, buddy. You're awesome. Thank you for the $20 super chat. Also, Jay Hart, the best mod on the internet. Have I told you lately? Jump kick backflip. Can never tell anybody that enough. Thank you, Jay Hart. All right, let's finish up. Yeah, there's about 5 minutes left. Yeah, I'm not gonna say I'm gonna let it play out because it's still 5 minutes, but it's probably going to happen. You guys are awesome. We jump in Discord after this. We hang out in the voice chat. We have a good time. So you've seen the Discord link. My mods keep dropping it. Also, it's in the description if you don't want to listen to the mods, you want to click it yourself. You don't have to listen to the mods. All right. You guys are awesome. Thank you for all the super chats, mods. You guys are all awesome. And super chats, gifted memberships, all the new members. You guys, thank you so much. And members only Monday, or now we're gonna call it Mom Day. So yeah, look forward to that. Let's go.
Okay, what's your name?
I'm Dustin Douglas.
Dustin. All right. Dustin, Mr. Douglas. I have to assume that you walked into the courthouse downstairs in the main entrance, and when you walked into this courtroom, that you paid attention to the signs.
Yeah, I turned my phone off. I just didn't understand the watch feature. Sorry,
All right, well, how long have you had this watch?
quite a while.
And what makes you not understand it today? It looks pretty beat up and old and used.
Because when I tried silencing it and I accidentally hit the alarm for my silenced phone, and I didn't realize that I've never tried to silence it before.
All
And I
right,
seen the off button right when I gave it to the
so
guy.
let me just be honest with you. So generally, I'm a little different than other courts. Judge Bolt, for instance, it's an automatic $25 fine. He's even fined himself, made national news for it, all right?
Oh,
I generally kind of let this.
This is one of the people that got kicked out of court. I think his phone was going off. They kicked him out. The other one that got kicked out was actually recording. So this guy, his phone just went off. So he's explaining, hey, it wasn't my fault. Yeah, but he got kicked out of court. So that's what's going on right now.
Stuff go because most people read the signs, are respectful of the hearings, and maybe it's just I have a little bit more patience. But I do have some days where the docket just seems to drag, and then you sat through this, and maybe you can imagine the court's pain, like when you have defense attorneys that never stop talking, and they always want to.
That's why I wanted this clip in there. This kid, his watch was going off. His phone just went off. The next one actually was recording, but that was the boom right there. Like, you have defense attorneys that just don't stop talking. I love it. I love it.
Interrupt. And so then it just kind of tries your patience and it wears on you, and you just want to deliver an opinion, and then the Court of Appeals can do whatever they want with it. And then when you have those extraneous noises go off and you kind of lose your train of thought, and some days are just like everybody, maybe more trying than others.
I get it.
So what I'm going to do, I find that you're in direct contempt of court and you have purged your.
I didn't understand what you meant for a second, Fozzie, and I actually thought that I had a super chat that I missed. So thank you for that.
Contempt by remaining here the rest of the docket to get your watch back. I'm going to hand this to you. You're free to go.
Thank you, sir. I'm sorry.
So let's also address the other contempt. Who was the owner of this phone again? This one's a little more problematic to me. So you were recording, correct?
Yes,
And I assume that you must have read the signs.
I did not see them. I did not know. I was just trying to take notes.
All right. So that's a much more serious violation.
Ed, not that I'm aware of. Why do you say that? Because we kind of look like each other? I don't wear glasses. We have the same color hair. Maybe we sound a little bit alike. I don't know. But yeah, but no, we have completely different last names. My last name is definitely not Cromwell. His is Schaefer. So yeah. Anyways, we're going to let this video play out. There's only a couple minutes left. You guys are all awesome. Thank you again for everything. This was a good video. Hope you guys liked it. I have a lot of content over the last 3 days. So we're going to be throwing... No, not for looks. Okay. All right. Yeah. We're not related. At least I don't think we are. Anyways, there's going to be a lot of videos coming out over the next couple of days. I haven't really put out a premiere or just posted a video in a couple of days, but I've been grabbing content like crazy. So there's going to be a lot of videos. So look forward to them. Anyways, let's go hang out on Discord. Until next time. Bye.
In my estimation, there's a reason, right? Because those recordings often get used for nefarious purposes in different situations, all right? For instance, you can have those recordings used to intimidate witnesses or participants or something of that nature. And that's why that's a fairly important rule. There is an official transcript. Everything in here, as you can see, is recorded, okay? And the official transcript of what occurs in a courtroom is the recording that's reduced to writing, okay? They're confounding transcripts. And as somebody speaking on behalf of a victim here today, you heard ad nauseum in that motion are referencing a transcript. That's the official proceeding of a court hearing. So whatever.
Pause number 1. Thank you so much, Jedi. Oh, Jedi, you're awesome. Thank you. Fred thought that he was going to sneak in a second pause, but nope, he was a little bit too quick. Thank you, Fozzie. I appreciate it. When does Jedi get to host again? Did I tell you how badass that video was? Yeah. She can come up whenever she wants. She can host. I don't care. She can do it whenever she wants to. All right, thank you both. You guys are both awesome.
Whatever you have that's recorded here is never going to be an official proceeding, and it can only be used for improper purposes, quite frankly.
It was just for my personal, just for notes, because I wanted, it's been a very emotional ordeal.
Right.
A 2-year investigation into this case involving my father and culminating in his untimely death. And it was merely just for closure for me.
All right.
For my father.
So you can order a transcript. What I'm going to do, I'm going to treat this the same. I do view this.
Second pause, legal fiction. Thank you so much. And Jedi coming in. Jedi wanted that. She wants to be right. She gets 2 pauses. Thank you for the 5 gifted memberships and welcome to the new members. All 4 of you are awesome. I like this little game you play. It's fun. I laugh every single time, and I always try to see who won, who's gonna win. So Jedi has it right now. She has 2 wins or 2 pauses.
More seriously than the contempt I just handled, though. So I do find that you're in contempt. You also have purged your contempt by the court requiring you to stay here throughout this proceeding. But what I am going to do is I'm going to order that you again continue to stay until I get my court officer back. When he's back, I'm going to hand him the phone, and he's going to work with you to turn it on. And then once you have showed him you're deleting that recording, then you're free to leave.
I will reset the whole phone.
Just have a seat there, and we'll see if we get him back. Okay. All right, who do we have? Anything else, Mr. Butler?
Oh, right at the wire. Right at the wire, Fozzie's cat. Finally made it back home. Ooh, yeah, you were running everywhere. You are a very lucrative cat. You just go everywhere. Thank you so much, Fozzie. That's 3 pauses. And yes, Ed, they do this at the end of every one of my videos. They think it's hilarious. And you know what? I'm not going to complain about it. So, yeah, it's what happens. Anyways, you guys are all awesome. This is actually over. The second I hit play, the outro is going to come in. So let's go hang out on Discord. Have a good night.
No.